Howdy, we are talking about Texas Rule of Evidence 410 today. I'm Brian Foley, board certified in criminal law, and I work as a criminal defense attorney here in Conroe, Texas. Help folks in Conroe, the Woodlands, in Montgomery County, and also Harris County and the surrounding ones. So, again, we're talking about Texas Rule of Evidence 410. The first part of this rule discusses the effect of plea bargains and plea discussions in a civil case. Okay. And it says in a civil case, evidence of a list is not admissible against the defendant who made the plea or was a participant in the plea discussions. So if you make a guilty plea and you later withdraw that plea, that cannot be used against you in a civil case. Okay. And here's the big one. This is the important part of this entire rule is a nolo contendere plea cannot be used against you in a civil case. This is the meat and potatoes of this rule, why this rule is important, because we would get, when I was a prosecutor, I'd have defense attorneys ask me all the time, when there was some kind of a civil dispute going on, if it was a car wreck case and there was a criminal case related to it, they would ask, can we plead no contest or nolo contendere as opposed to pleading guilty? And the reason was this rule right here, which says if you plead no contest, you can't just enter in the judgment and then they win the civil case. You have to actually go forward on the civil case and meet the burden of clear and or not clear and convincing, but a preponderance of the evidence, which is the burden in a civil case. The other things listed here are a statement made during a proceeding on either of those pleas. So if you make a statement like in a federal case, they'll have an investigation phase. When you plead guilty, you give a statement related to that in order to enter into the agreement. You can't use that. Or a discussion made with the prosecuting attorney or the attorney of the authority involved. Anytime a defendant represents themselves, let's say, and not through an attorney, they might make plea bargain negotiation statements like, yeah, I did it. If I just admit to doing it today on the first court date, will you give me a better deal? This is a really terrible strategy. I don't ever advise someone to talk to the prosecutors by themselves, or maybe ever if you can avoid it. But if you do happen to be involved in a plea discussion or a negotiation, that is going to be excluded under Rule 410 under the civil, if they're trying to offer it in a civil case. All right, and the second part of the rule discusses criminal cases. In a criminal case, evidence of the following is not admissible against the defendant who made the plea or was a participant in the guilty plea discussions. So it's pretty much the same list, right? The only difference is the no contest plea can be used against you in a criminal context if it was not later withdrawn. So how would they use it? Well, if you were a prosecutor and you were trying to prove that someone committed an offense for an enhancement purpose or for something like that, then a no contest plea can be used against you as long as you did not withdraw the plea. A withdrawal of a plea happens when you get up to the bench, the judge starts asking you, did you enter this plea freely and voluntarily? Maybe you had a bad lawyer and they didn't answer all your questions. The judge starts asking you those things, you get cold feet and you withdraw your plea. You can do that anytime prior to the finalizing of the plea. And so that's what it says here. Any guilty plea that's later withdrawn can't be used against somebody, and any no contest plea later withdrawn can't be used against them. And the same thing with statements. If you made a statement during the process or during a proceeding or just a statement to the prosecutor, that can't be used against you later on. So let's look at some case law. It is United States versus Robertson, and that case says that Rule 410, in that case, the Federal Rules of Evidence, doesn't include every statement made by a defendant trying to work out a better deal for himself. So the example in that case was there was a discussion with police officers in the parking lot where he was arrested. He was trying to work out a better deal for himself, saying, yeah, I did this. Maybe I can tell you about some other people who are doing drugs or something like that. If you're trying to work out a deal with the police, that does not equate to plea negotiations. It really needs to be a negotiation with an attorney for the state because the police don't ever get to decide those things. And then the last part here is what we call the exception. This is literally written into the rule just as exception, its own subheading. And it says, in a civil case, the court may admit a statement described by paragraph A3 or 4. Those are the statement ones, not the plea of guilty or the plea of no contest itself, but statements that go along with it. You can enter in those, and in a criminal case, the court may admit a statement made as the statement, not the plea itself. When some other statement made during the same plea or plea discussion has been introduced, and in fairness, the statement by the defendant ought to be considered. So, for example, if a defendant says, well, when I was pleading guilty before, I said really that Joey had all the drugs. Well, if you're going to get to say and offer evidence that during the plea bargain negotiations, you said Joey had the drugs, but you also said you knew about the drugs, well, then the prosecutor is going to be able, under this exception, to introduce that statement, even though Rule 410 would normally not allow that. This is kind of similar to when you look at the rules that relate to admitting part of some other recorded document that, in fairness, ought to be read contemporaneously. And it's not part of that same rule, but it is an exception here. And it's kind of a what's good for the goose is good for the gander. You're not going to get to talk about part of the statement and then get the prosecutor to exclude all the statements that you made that you don't want anybody to hear. So if you're going to try to enforce this rule, don't go halfway, go all the way. Don't talk about anything that happened during the plea bargaining process. I hope you enjoyed the video. If you like what you saw, remember to hit that like button, subscribe, ring the bell for notifications, and we'll catch you next time on Texas Rules of Evidence.